Good morning, everyone. You know my name is Judge Gilson. With me is Judge D'Almeida and Judge Bishop Thompson, and we'll be hearing Charles Kratovil versus the City of New Brunswick. And this is under docket number A-0216. And welcome, and we'll take your appearances beginning with counsel.
Good morning. My name is Alexander Shalom from the American Civil Liberties Union of New Jersey Foundation on behalf of Charles Kratovil.
Good morning, welcome. And then for the City of New Brunswick.
Good morning. My name is Susan O'Connor. I'm from Hope Longer Moran Dunstan Dukas. I have the City of New Brunswick and former Director of Caputo.
Good morning. Larry?
Thank you, Your Honor. Good morning. Vito Gagliardi from the firm of Porzio, Bromberg & Newman on behalf of the Amicus New Jersey State Association of Chiefs of Police.
Sorry.
That's all right, Your Honor. Good morning. My name is Frank Corrado. I'm with Barry Corrado and Rossi and Wildwood. I'm here on behalf of MIKI, the Reporters Committee for Freedom of the Press, and several media organizations, the New Jersey Press Association, Gannett, Media News Group, and New Jersey Advanced Media.
All right, thank you. I apologize. Point out
Morning, Your Honor. I'm Robert Cannon, C-A-N-N-A-N, firm of Markman and Cannon. We represent Amicus, State Troopers Fraternal Association of New Jersey. Good morning.
Good morning, Your Honor. Assistant Middlesex County Prosecutor Randolph Mershon on behalf of the County Prosecutors Association of New Jersey.
Good morning, Your Honor. Paul Kleinbaum of the firms Zally, Fagella, Nowak, Kleinbaum, and Friedman on behalf of the Amicus New Jersey State PVA.
Morning, Your Honor. Richard De Fortuna, firm Markowitz and Richmond, on behalf of the New Jersey Fraternal Order of Police.
Good morning. I apologize, I don't think we have another chair for you, but you can always feel free to sit.
We'll switch off, Your Honor.
All right. Generally, we give you about 15 minutes aside if you want to reserve any time. But before I get into that, have you discussed how you're going to allot your time, or are you going to make the primary argument?
My plan was to make the primary argument, and Mr. Corrado will clean up any mistakes I make thereafter.
All right. Well, I'd like to
I don't.
reasonable about it. We'll give you the full 15. Mr. Corrado, how much time do you think you're going to need?
No more than 5 minutes, Your Honor.
Okay, that sounds reasonable. And on the other side, have you discussed how you'd like to present it?
I'm hoping to be less than 15 minutes, but I know I have a group of counsel here that will also wish to speak.
Go ahead. Your Honor, we had discussed amongst ourselves presenting the matter here, similar to what we did at the trial court. I would go less than 10 minutes, and each of these gentlemen would ask for an opportunity to speak as well.
Your Honor, we discussed, to address the concerns that you've raised, we had discussed with the court's agreement an order in which the Amici will argue after Respondent's counsel. And we're doing that to try to avoid any repetition of argument, and don't expect to be more than a few minutes each. That's correct. So Mr. Gagliardi will argue on behalf of the Chiefs Association, Mr. Mershon on behalf of the Prosecutors Association, Mr. Cannon on behalf of the State Troopers Fraternal Association, Mr. De Fortuna on behalf of the FOP, and I'll follow with on behalf of the State PVA.
All right. That all sounds reasonable. If I think you're repeating yourself, I might give you a little guidance on that. So with that said, we'll be pleased to hear from you.
Thank you. May it please the court if I might reserve a minute or two for rebuttal?
Certainly.
Thank you. I'd like to explain why this case is a classic unconstitutional prior restraint, and alternatively why it fails under the Daily Mail test. But before I do that, let me explain what this case is not. This case is not a facial challenge to Daniels Law, nor is this case a challenge in any way to the provision of Daniels Law that allows the government to decide what information it makes public. it has chosen not to make public the home addresses of judges, prosecutors, and police officers, and former judges, prosecutors, and police officers, and it may do so, and this lawsuit does not challenge that in any way. Instead, and as recognized by the Attorney General when they declined to participate in this case, despite their obligation to defend the constitutionality of state statutes, this is an as-applied challenge that asks simply whether in a case where a journalist lawfully obtains truthful information that is easily and readily available to the general public through the internet, obtains it from the government, and wishes to write a news story that contains that information on an issue of public concern, whether the government may lawfully prohibit him from doing so with the threat of civil and criminal penalties. It may not.
Counsel, I want to make sure that I understand these statutes correctly. In order for the statutes to apply, the covered person has to first provide notice that they wish to prevent the dissemination of their home address?
That's right. There's maybe even a step prior to that, which is there are people who are potentially covered. I've listed the groups. They then have to seek coverage, and if they've done that and become a covered person, as we are kind of assuming for the purposes of this argument that Director Caputo has, then they must provide notice that they, essentially in the form of a cease and desist letter.
Did Director Caputo request that the Board of Elections not release his home address?
So that's a separate question. If he was a covered person, and we don't know whether he was, they should automatically know that to not release the address. We don't know what the timing was. We kind of infer that he's a covered person today. We don't know whether he was a covered person at the time.
Why would he not have been a covered person?
If he failed to register as he was required to, and we just don't know the timing of that registration.
Is that important for our analysis?
It's not, because we're assuming that he is a covered person. We're assuming that the assumption that is baked into all of the briefs is that the Cape County Board of Elections erred in providing the information to my client.
What if they didn't err?
Then Daniel's Law doesn't reach my client. Well, that's not true.
Well, there's a second request by the director to not release his home address.
Correct. Assuming he is now covered, whether they erred or not, my client still faces the risk of civil and criminal penalties under Daniel's Law. So on the prior restraint question, this case is a prior restraint, and prior restraints come before this court with a strong presumption of invalidity.
Now, when you say it's a prior restraint, the letter here was sent not by the prosecutor's office, but on behalf of the former police director, correct?
It was sent by the city, on behalf of the former police director, with a copy to the prosecutor's office, referencing statutes that invoke civil and criminal penalties. And what makes it a prior restraint is that he is being told he is not able to publish a newspaper article. And although my friend from the city...
No, he was told he's not able to publish the actual home address of someone.
In his newspaper article, that's correct. But that's the way all prior restraints operate. I mean, when we think about the Pentagon Papers, the New York Times wasn't told you can't talk about the war in Indochina. They're not told you couldn't talk about this report that the Rand Corporation said. They said you couldn't, what the government was alleging was you can't reprint this stolen report. And the United States Supreme Court found that that was a prior restraint that was unlawful. And they basically said every prior restraint, this is Justice Brennan's concurrence in the Pentagon Papers case, every prior restraint that does not pose a risk of imminent, imminent, and direct harm is forbidden. There aren't exceptions. We talk about Neer is the case. Neer versus Minnesota is one that is theorized that during a time of war, active troop movements might be able to be prohibited. That's it. There aren't other examples. But I want to kind of assure the court, you don't need to go as far even as to say this is a prior restraint and therefore we're striking it down, because the Daily Mail line of cases provides a very simple way to do it. I'm going to spend a moment going through the 4 steps on why Daily Mail applies and then explain why.
Before you do, if you could just, neither statute defines home address.
That's right.
what is your client's position with respect to what a home address is?
My client's position is that, as is evidenced from the briefs, the defendant gives an answer which seems contradictory to the answer that their client had given. It seems like my adversaries have come to the conclusion that home address would be 123 Main Street, New Brunswick, New Jersey, something like that. It is certainly unclear in the statute whether he could say Main Street, New Brunswick, New Jersey, whether he could say New Brunswick, New Jersey. All parties at Amicus seem to concede that they wouldn't seek prosecution under the statute for saying Cape May, New Jersey. But it's unclear whether he could also say Main Street or also say 123 Main Street.
Or what if he said the Kramer Hill neighborhood of Maine?
Or a beautiful colonial home in Cape May, or a White House, or
3 houses down from the post office.
or a $3 million home. There are lots of descriptors one could give that would narrow down, and the statute just isn't clear on that. I do think the vagueness is part of my concerns, but even accepting the narrowest definition, Mr. Kratovil is restrained from writing the news story that he wishes to write. So, the Daily Mail test first asks whether the person is a journalist, and there is no reasonable debate as to whether or not Mr. Kratovil is a journalist. Next question is whether the information was lawfully obtained. There's some fuss and bother, but ultimately, he filed an Oprah request, and the government gave it to him, and so whether he gave incorrect legal advice to the Cape May Board of Elections or not, they gave him the information, and he did not make them break the law. They chose to, assuming that they did. There are lots of cases in the Daily Mail line of cases where government entities broke either norms or laws to provide the information. Sometimes people even broke the law. So in Bartnicki, there was a violation of the Wiretap Act, but the violation wasn't done by the people who wanted to publish it, and that is therefore treated as lawfully obtained. So too here.
A home address is information that can be obtained by anyone. You could follow someone home.
That is certainly true. You could follow someone home. And in this case, it's worse than that, Judge de Almeida, because Director Caputo's address was and is easily available by a simple Google search. I cited to a news article in my papers where the reporter who was reporting on the controversy here, the inability of Mr. Kratovil to write about the home address, said, by the way, I found the home address. It took one easy Google search. So what we have is the only person who can't report on the home address is the person who wants to write an article critical of the home address, effectively, of the relationship of the home address to the work address.
But that's going to be true almost in every situation with Daniel's law. I suspect that if you Googled my home address, you could find it somewhere. But what Daniel's law says is, having found that, you can't republish it in a situation that might put a judge's family at risk. That's what the state is trying to protect against. So, the fact that it's out there doesn't necessarily excuse the republication of it, because that's what Daniel's law, as I understand it, is trying to protect against.
Judge Gilson, I don't think that the ready availability of it is dispositive of the case. Certainly not. It's not even an element of the test under Daily Mail. I'll let Mr. Markman speak for himself, but when he was arguing before the trial court, he explained that his union, the STFA, spent a lot of time doing internet hygiene on behalf of his the members of his bargaining unit, which is to say they went onto these websites and said, please remove this, please remove this. And the failure of Director Caputo to do that, but yet to go after Mr. Kratovil, is what makes it, this as-applied challenge makes the restriction particularly odious, because it doesn't help that much. Because someone who wants to do Director Caputo harm can still find the address. So the marginal benefit is low, and yet the harm in restraining the First Amendment, or in this case Article 1, Paragraph 6, is extremely high.
Let's focus on the facts of this case, because what the trial judge ultimately ruled in this case, as I understand it, was your client can publish that Director Caputo lived in Cape May. And that's really the significance of the story, isn't it?
No, and it's not the job of the trial court or of this court to decide, to make editorial decisions. That is the nature of the First Amendment. The First Amendment delegates that responsibility to the free press, to reporters and to editors, to decide what goes in their story. And in this case, the court is acting as an uber editor, trying to decide what facts are appropriate and what facts are not. And that is not something that the First Amendment has ever.
So but I understand your argument, and the editing part really does raise a troubling issue. But at the same time, if you look at what the case law requires you to analyze, is what is the significant government interest? And the interest is protecting people from violent attacks. Now, it's based on a law of really tragic circumstances.
Without a doubt.
And it's the reality of the situation today is that there are risks faced by certain public officials if their addresses are out there. So your argument, if we accept it, is in essence saying, well, the state has no interest and really can't act, protect, because if you get into the province of news reporting, then it's up to the news reporter to decide whether they are going to publish or not publish. And that does seem to go, there's a difference between Director Caputo lives in Cape May and Director Caputo lives at blank ad number on blank street in Cape May.
Judge Gilson, respectfully, that is not at all the position that we take, that there's no government interest, but that's not the test. The test is that the government's law must be narrowly tailored to achieve a need of the highest order. That's the test that the government fails.
Doesn't it become a higher order because you're looking at what is your client's interest? And his interest is saying, hey, people of New Brunswick, are you aware that the director of the police department actually lives in Cape May?
But Judge Gilson, I think you're flipping the burden here. It's not about my client's interest. My client's interest is the First Amendment. The question is, can the government overcome that?
I'm saying that when it gets down to the specific address, how doesn't the government's interest raise to a significant level?
So I will get to that question in one moment. If I could first get to the question of the public interest, is this a matter of public interest or private interest, which is one of the issues with which we disagreed with the trial court, and I think is the crux of this. Everyone agrees, trial court, even I believe the defendants, and that generally speaking, and Your Honor's question alludes to this, generally speaking, the Cape May piece is a matter of public concern, that you have a high-ranking police official living 2 hours from his place of employment is a question of public interest. What the trial court said is, but the specific address is not a question of public interest, and that's where your question was kind of getting at. But if you look at the cases, that is not how the Supreme Court analyzes questions of public concern versus private concern. And that's true in the Daily Mail line of cases and in other lines of cases. So in Daily Mail, look no further than the Florida Star case, BJF. So in BJF, there was a rape, and the government erroneously disclosed the identity of the rape victim. Keep in mind, this is before the perpetrator had been caught. So the perpetrator is at large, and the Florida Star publishes the rape victim, BJF's full name, putting her at risk, not just her privacy, but her safety. And the court, in evaluating whether this was an issue of public concern or private concern, didn't say, is BJF's identity an issue of public concern? They said, is rape and crime in general an issue of public concern? And once they made that predicate finding, which they did, then the name was, of course, related to it. And that's the question. Is it related to a matter of public concern? Not, is this specific fact? Because otherwise, you convert judges into editors. And the same is true in Snyder v. Phelps, the case about picketing.
But when you say that, isn't the evaluation of public versus private concern exactly exactly that issue of looking at and determining is this a matter of public concern?
No, does it relate to a matter of public concern? And that's what prevents judges from being editors. Because once you decide that the topic is a matter of public concern, you don't get to decide how it's reported, whether you say it's a Victorian house or it's 3 houses from the shore. That is the critical difference. And so in Snyder v. Phelps, there were lots of signs that were on political matters, distasteful but political. But there were a couple signs that were decidedly personal. When you say at someone's funeral, "You're going to hell," or "God hates you," that is personal. And Chief Justice Roberts noted that, but still said the overall thrust of the message was on a matter of public concern. Here, the overall thrust of the article, by the trial court's concession, is a matter of public concern. We don't then let judges get into the business of deciding which facts can be included, which descriptors, and which details.
Counsel, on that point, I just want to clarify the record. Are we talking about Cape May the municipality, or Cape May the county, or Cape May the geographic entity? Was that
I
clear?
think the answer is yes to all three,
Okay.
which is to say I believe it is Cape May Township, but
Or borough, I think it's a borough.
It's the city.
it's the city.
So, and the judge made that it was the municipal level that we had a finding here, that was what was of public interest.
I believe that's right. I will, when I get up at rebuttal, I'll be able to confirm that. I'll go back and recheck the transcript, but I believe that's right. Okay, and so in that framework, once you decide that it's related to a matter of public concern, then it's got to be narrowly tailored to achieve a need of the highest order. I don't think the court has to get to the question of is this a need of the highest order because it fails the narrowly tailored test. It does so, and you can see this in the Schrader case, the case from the Third Circuit, which says, are there alternatives? And in this case, there are at least 3. The first is that the city, the government in general, can do a better job policing itself. We have some statutes, like the expungement statute, that provide a penalty, a financial penalty, when government agencies erroneously make disclosures. So that sort of negligent disclosure is penalized as a way to try and prevent people from doing it. There could be training, there could be auditing, and there could be punishment, none of which the Daniels Law scheme sets up. So that's way 1. Way 2 is exactly what the federal Daniels Law does. The federal Daniels Law has all of the same prohibitions, but makes an exception for journalists writing news articles about issues of public concern. So the federal Daniels Law builds in the First Amendment protection that we think is missing here. And finally,
Getting back to your first comment, you're not challenging Daniel's Law across the board. You're saying just as applied.
just as applied to Mr. Kratovil.
And so, in terms of that, we wouldn't need to necessarily reach that issue.
That's right. If you look back at the Attorney General's declination letter, what they are clearly asking trial court and now this court to do is rule as narrowly as possible. They don't want you to strike down Daniel's Law. They believe Daniel's Law is constitutional. We didn't challenge the constitutionality of Daniel's Law. What we're asking you to say is when you have someone like Mr. Kratovil who lawfully obtains information, true information from the government and wants to write about it in a story that is related to an issue of public concern, Article 1, Paragraph 6 demands that
Well,
they
it's
be able
actually
to do
more
so.
narrow than that. Not like. When you have this situation.
Yep.
With these facts, what happened here was in fact a prior restraint, and therefore we simply reverse on that. Isn't that what you're really asking for?
You can choose whatever theory you would like to reverse, and I would accept it, but that is right. That is, if you look at our complaint, the relief that we seek is just what you just described, Judge Hilson.
And then it's just narrowed to these facts.
That's right. That's right.
And the arguably unique circumstance of obtaining this information through an open request of a public entity.
It would be left to someone else to later litigate whether, if you obtained it in some other way, following someone home or something like that, whether, what would apply to them. But this case is unique for several reasons, one of which is that this journalist obtained it through, from the government.
It helps your client's position without a doubt. If the government's interest is so strong, why did the county board reveal this information?
Exactly so. Exactly so.
And so your alternative number 1 would apply here, assuming the county board erred, and we're not sure that they erred, right? Because we don't know if he requested that his name or his home address not be released. If they did err, then the government could in some way penalize the actors at the county board of elections, or better train the county board of elections, or provide them better legal advice.
For sure, and whether or not they can go after the county board of elections probably depends both on whether the board erred and on whether there's a mechanism to do so, but yes, I think that's right.
And is it, I just want to still get this clear, if there has not been a request by a covered person to not disclose their name, their home address, is their home address available at the county board of elections, assuming they're registered to vote?
So that's a good question. I mean, essentially what you're asking, Judge Almeida, is what is the default under OPRA? Are home addresses of postal carriers and ACLU lawyers available? I think the answer is they probably would be available.
Isn't Baza versus Jersey City, that's the case where the
Bazzi?
Bazzi, where the court said if you
That
get
was
a
the
dog
dog
license,
license?
your home address is available under OPRA?
Yeah, so having just argued a case at the New Jersey Supreme Court called Rise Against Hate,
I'm familiar.
I'm sure you are. I'm not sure that Bazzi answers the question because at least some members of the court thought that the public nature of dog licenses were dispositive. Other people thought that home addresses themselves were.
Public nature of being registered to vote?
Certainly I agree with that. I think that's true, that sort of information is highly relevant, and you can think of lots of reasons why you'd want to know geographic trends and things like that. But I'm not sure that it's, first of all, I don't think it's necessary to the resolution of this case, but I want to just in candor say I'm not sure that that has been decided by the New Jersey Supreme Court. Unless the court has other questions.
Well, you were giving three alternatives, you only gave two.
The third is that this statute provides both civil and criminal penalties, and that's obviously harsher than civil penalties alone. We don't think number 3 alone is the thing on which the court should hang its hat, because civil penalties alone are sufficient to deter Mr. Kratovil from publishing, but we do think that that is further proof that it's not narrowly tailored. And unless the court has other questions, I'll save the rest. Ask you to reverse those. Thank you.
Do you want to be heard?
Just briefly, I can be very brief because Mr. Shillo, first of all, good morning, may it please the court. I can be very brief because Mr. Shillo has touched on most of the points that my clients who are journalists would want me to make. The most distressing aspect of the decision below to my clients is this idea that a court can become a super editor or a neuter editor. And that's exactly what happened in this case. The trial judge decided what the story was about and then decided what facts were necessary to convey what he thought the story was about. As Mr. Shalom said, that is simply not a court's job. Once there is a finding that the matter involved is a matter of public interest, it goes beyond a court's task to start deciding which of the facts that relate to that matter of public interest are relevant to successful telling of the story.
To some extent, and I apologize for interrupting, but the interesting thing about that is you're saying that Mr. Kratovil was the one who came to court. He says, before I publish this, I want an injunction, and I want to know what my rights are. So he's asking the court that question, isn't he?
Well, he's asking the court whether the constitutional protections that he has under the law apply in the particular circumstances of this case. I don't see the fact that he had received, as I understand the facts, he had been threatened already by the city of New Brunswick that if he published this information, he would be either civilly or criminally prosecuted. So I don't think that the fact that he asked the court to clarify what his rights under the Constitution of New Jersey were somehow flips the burden or requires it eliminates the fact that a court can't pick and choose what relevant information goes into a story about a matter of public interest. The judge seemed to think that it was necessary for him to decide what was relevant to the story and, you know, what the story needed and what was not, whether it was necessary to have a particular fact or not a particular fact. The question that he should have been asking is whether the ban on publishing that particular information was narrowly tailored under the standards of the Smith versus Daily Mail case. And he didn't ask that question, as Mr. Shalom indicated. I think he essentially flipped the burden. There are two fundamental principles of First Amendment law that New Jersey constitutional law that apply here. The first is that the mere I think that Smith versus Daily Mail and its progeny require that there be at least some evidence that there is going to be harm related from the harm as a result of the publication. The mere undifferentiated fear or apprehension of damage or injury is not enough to punish or restrict speech. That's Cohen versus
Apply that to
California.
troop movements. You know, the publication itself isn't going to cause the harm to the troop movement. It's the fact that the enemy could read it and then act on that and put those troops' lives at danger. And I take it you're conceding that that one is an example of where the government could act. And
If
say
there were
to-
some information that the government had, yes, yes, but.
So we don't have to wait till a public official is actually
Oh, of course,
harmed
I'm sorry.
in order to try to protect their
Of course
own
not, but there
press.
has to be something more than the mere undifferentiated fear or apprehension of damage. There's no one in this room who doesn't, I don't think, who doesn't believe that that the legislative finding that there is this possibility that gave rise to Daniel's law is not a significant finding of fact. But
Mr. Cronin, to evaluate your argument, would we have to know how widely available the director's address is?
I don't think so. If I understand your question correctly, I think that the key to this case is whether there has been proof adduced by New Brunswick, because the burden of proving narrow tailor, that it's not narrowly tailored, is on New Brunswick. It is not on Mr. Kratovil.
But
Mr.
if
Kratovil doesn't have the obligation.
your argument is that you have to have, the state has to have more than just a fear of harm.
Correct.
And would that argument, would we be able to evaluate it if we knew that his address was already widely available?
I think
And that
that's
this
true.
would not change that
Right.
equation by much.
I think that's true.
But do we know that from the record?
We know that a Google search would uncover his address.
Well, that's not really part of the record.
It's not, well, that.
I mean, somebody has said that.
And when you look at these other cases, it's easier to make the determination that the information isn't readily available.
That's true.
Troop locations are not readily available.
True.
The name of a rape victim is not readily available. But this strikes me, although we don't have a record that says this, the information that's at issue here might already be readily available.
Yeah, but I don't think that affects whether New Brunswick can demonstrate that prohibiting the publication of this information somehow is necessary to advance a compelling governmental interest of the highest order. And that's my point here. I don't think that the trial judge's decision recognizes the need. He focused on the necessity, whether it was necessary to include this information for Mr. Kratovil to tell a story that he wanted to tell. What he should have been focusing on, and what he didn't focus on, was whether the ban on publishing this information advanced the government's interest. And that's where he sort of, I think, got it backwards. And that's one of the things that troubles my clients so much. Let me say one further thing about the prior restraint issue. I agree entirely with Mr. Shalom that this is a prior restraint. This, as a matter of fact, resembles the original prior restraint, which was that you had to go to the censor, to the authority, to get permission to publish. And that, in essence, is what New Brunswick was, what the trial judge was telling Mr. Kratovil. You have to get my permission before you publish it. The defendants say at some point in their papers that it's not really a prior restraint because he can publish some of the information, but not all of it, just not the information that might not be necessary. And that doesn't make it less of a prior restraint. In fact, from my point of view, I think it makes it worse because it turns it into a content-based prior restraint. He says, the judge says basically, you can publish X, but you can't publish Y. And the reason you can't publish Y is because of its content. And as the state Supreme Court has made clear in a number of cases, including Murray versus Lawson, a content-based prior restraint, or a content basis for the restraint is one of the factors that goes into determining whether a prior restraint exists or not. It also goes back to the original point that I tried to make. Again, that's a way that the judge is sort of acting as an editor. You can publish this, but you can't publish that. So
I think we understand your point.
Okay.
Anything further? Thank you very much.
Thank you.
Your Honors, every day we hear something else in the newspaper with respect to bomb threats to capital cities, actions against judges, action against law enforcement, and action against prosecutors. There is no question that there is a harm that the government is trying to protect, and that harm is a substantial interest of the government. Counsel has indicated that this is a prior restraint case. Under Daniel's law, one must provide notification. Every time someone provides notification, and the letter is clear that it is not a threat, but every time somebody provides notification, that does not make it a prior restraint. That is complying with Daniel's law and the notification process. And as Judge Gilson noted, it was plaintiff who brought this lawsuit.
But the purpose of the notice is to inform the journalist that he will be subject to civil or criminal penalties if he publishes certain information.
The purpose of the notification is to inform the journalist of the statutes in case he or she is not aware of it, number one. Number two, the notification is a precursor, if you will, to the journalist's ability to post, repost, publish, or republish.
That sounds like a restraint.
I disagree with Your Honor, only because it is not a restraint, it is a notification. They're not saying do not publish. The notification specifically said, these are the statutes, and I'm asking you not to publish. It is still up to the newspaper reporter whether or not he or she wants to publish. There is nothing that indicates in that letter that Director Caputo would take action should he publish. All it does is say, and again, not a threat, these are what the statutes say. Therefore, under the notification, it couldn't possibly be considered a prior restraint.
But that's not factually how this one came about. If I understand it correctly, Mr. Kratovil went to a public committee meeting, stated the address in public, handed it out to some council members, and then gets a letter saying, don't do that again, or you'll be subject to these penalties. Isn't that how the letter reads?
No, actually, the way the facts are is Mr. Kratovil went to a council meeting, published the address. No action was taken because notification had not been provided. Action under the law cannot be taken until that notification is provided. So it is with respect to And just so we're clear, the record's also clear that Mr. Kratovil has published the, if you will, meat of his story. That is that he alleges that Director Caputo was in a no-show job and that he lives far from New Brunswick. None of the codes require living in New Brunswick. And also with respect to the ability to direct whether or not this is a matter of public concern, there's no question that under Judge Ray's ruling and under all the publications he's done with Twitter and all the articles that other newspaper reporters have published, that the essence, if you will, of the story is easily transmittable. We do not contend that Cape May cannot be used in the article, which would establish that, I think Judge Ray noted it was 130 miles from the place where he at the time worked. And as I've indicated in my briefs, he no longer works at New Brunswick. However, putting a street address and a street number with respect to the house is in contravention of the highest order of the state.
Counsel, is it a street name alone enough to convey a home address under the statutes?
Depending upon the size of the street, of course it is. If you live on or someone lives on a road that is a highway, perhaps not. But if someone lives in a small town that has very limited streets, if you will, it's not that hard to figure out where the person lives.
So is your client's position in this case that the street name alone would be enough to violate the statutes?
Yes.
How did Mr. Kratovil know that before the judge ruled on that issue?
How did he know?
How did he know he could safely publish that Director Caputo lived in Cape May, but he couldn't publish the actual street name and number?
I think Your Honor is looking with respect to the definition, if you will, of home address,
Yeah.
right? And it is my opinion that it's a common sense definition. It is people of common sense that they can know what a home address is. Home addresses don't necessarily mean the state that you live in or the county that you live in. With respect to his Twitter feed, he specifically talked about the fact that he lives far away. So even after receiving the notification pursuant to Daniels law, he still was able to convey the theory of his story with respect to this, quote, no-show job.
But, you know, as you get into that, it does raise the question of, isn't that really either the court or a government entity editing a newspaper article?
Well, I don't believe it is an editing job. The law is
Explain to
clear
us
with
how.
respect to, the law is clear with respect to the address. The law is clear with respect to the reason why law enforcement officials' addresses are protected. So the address itself, listen, I would be thrilled if he didn't even put Cape May, but he merely put 130 miles away. But the fact remains that a home address where you can identify, where a bad actor can identify a person and where that person and that family lives is inconsistent with the state public policy that's enunciated in Daniels law.
Counsel, it's a municipality. Cape May's pretty small. Is it
Yes.
possible that a municipality can be small enough that that would constitute a home address
It
under the
could,
statute?
Rocky
Rocky Hill, I'm just familiar with this town, only has 250 houses in it.
okay,
And is that small enough to say, well, you're really giving a home address, you can drive around that town in 10 minutes?
so again, the preference is that the town would not be given. In this instance, we have made the offer that the town could be given. I am not saying that all Daniels law cases from here on in should include the town. I certainly am not saying that. But in this instance, because we are talking, of course, as an as-applied challenge, Mr. Kratovil was not addressing the constitutionality of the statute on a facial basis. He's been very clear about that, etc. But then he starts talking about narrow tailoring and alternatives with respect to that narrow tailoring. That goes to the statute, and the facial constitutionality of the statute.
Can it be applied here?
In the,
Did-
as applied here, I
Did the
do not
director
think
take
so.
any steps to,
Sorry.
did the director take any steps to prevent the dissemination of his home address prior to the notice that was given to Mr. Kratovil?
The director registered for Daniel's Law prior to the notification to Mr. Kratovil. The director was unaware that Mr. Kratovil had gone to Cape May prior to the notification and prior to him actually coming to New Brunswick and sharing not only the information on the record but also the paper documents with counsel.
Did the director register for Daniel's Law before the County Board of Elections revealed his address?
That I do not know. I know that the director tried to register a number of times with the website, but apparently there was issues with the website initially. He thought that he was registered beforehand, but I don't know what his official date of registration was. The fact is that Cape May, and it's in the record, the Cape May, when they first were approached with respect to this OPRA, they said, no, under Daniel's Law, we cannot give you this information.
Is that because they were aware that he was the police director? How did they know that?
I can't tell you what Cape May was aware of at the time. I don't have the documents with respect to that transaction. But I would like to think that Cape May was aware that he was a law enforcement officer or prosecutor or a judge because they said Daniel's Law, right?
It's a small town. That gets back to that. Maybe
Yeah.
they knew.
Right. So I can't necessarily say that what Cape May knew at the time, but on the first go-around, if you will, they indicated to Mr. Kratovil that this information is protected. And quite frankly, the record's clear that Mr. Kratovil knew that the information would be protected because he had received notification from J.T. Miller, who was the deputy director at the time. And he indicated that that information was protected under Daniel's Law. Undeterred, Mr. Kratovil continued in his quest to get this information and then began to publish it.
What, if anything, is the significance that Mr. Kratovil went back a second time to the Board of Elections?
The significance, the judge underneath has indicated that it can't be said that he legally got the information. But the fact remains that he went back and he described cases to the Cape May clerk that I don't think were accurate.
But still, it was released by the Board of Elections, correct?
It was, and as plaintiff said, we're going to assume that's an error with respect to Cape May because they had taken the stance first and then they, quote, relented, if you will, on that stance. But the fact is that the the law specifically talks about the publication and the republication, the posting and the reposting with respect to the issues and the address. So the fact is that the Daily Mail case, which seems to be at issue, is that it's a matter of public significance. And there's no question that we're not blocking or even commenting on Mr. Kratovil's desire to publish this article, if you will, of public significance. But there is a need to further state interest in this case. And the state interest, as I've indicated, is, and I think your honors have indicated as well, you do not need to wait for the harm to occur before it becomes a state interest. There's plenty of information that indicates that this state interest is of the highest order. There are plenty of issues where newspapers that you read where it shows that there's interest of the highest order. One of the questions I think your honor asked was whether or not, might have been you, whether there was dissemination and whether or not the dissemination, if there's already dissemination out there, whether or not does it matter what Kratovil publishes? And the answer to that is yes, it does, because the dissemination is not necessarily does his neighbors know. who he is. The dissemination is not necessarily, with significant searching can you find it, and I think that there's been efforts to clean up that act. So, and again, Google's not in the record, but there is a case out there that talks about an individual interested in controlling the dissemination of personal information does not dissolve simply because the information is available to the public. The fact remains that what this case is about is the protection of Director Caputo, protection of his family. And to not permit bad actors to come forward based upon the easily accessible information that you can get from the internet at any time. I just want to make sure I address the questions that you
So
were
this, in this circumstance, in this case, with these
Yes.
facts, the state's interest may be in the preventing the further dissemination, even if it's already available. There's an interest in shutting down one avenue to find this address.
Sure. And as we all know, the internet is wide-ranging, and to, if you will, vacuum up all of that information not only takes time and effort, which has been made in our instance, but that does not indicate that someone should be able to write an article with respect to whatever they want to say, but also put it back in the public consciousness, if you will, that particular address, and where anyone can go find Director Caputo and or his family. So the last thing I want to say is that Judge Ray was correct. This statute is performed in a narrowly tailored way with the least restrictive means. There is no question that Mr. Kratovil can write his article. There is no question that Mr. Kratovil can convey what he deems to be a matter of public interest in an effective way. And therefore, I'd ask that your honors.
Counsel, is the criminal liability, does that make the statute too broad? It's no longer narrowly tailored. There's also criminal sanctions available to the state.
There is the potential of criminal sanctions, third or fourth degree. There is also the potential of civil sanctions.
The criminal sanctions have a different element than the civil sanctions, right? The criminal sanctions require an intent to harass
Yes.
or recklessness.
Just like any crime, with respect, you have to provide intent. I can't tell you whether or not you would be able to provide intent of a newspaper reporter with respect to the publication, but there are certainly circumstances where the reporter's actions before and after the article may prove that intent, but that doesn't necessarily invalidate the law. In fact, what it does is it permits, if you will, it permits the state to establish how much of a higher interest this really is and how crucial it is with respect to protection of our covered persons. Does anybody have any questions? I appreciate it. Thank you very much.
Morning, Your Honors. May it please the court. It is a privilege to appear before this court on behalf of Amicus Curiae, New Jersey State Association of Chiefs of Police. And since you've given me the opportunity to appear here as a friend of the court, I'm going to try to be exactly that by abandoning some of the things I was going to say and addressing some of the questions. The good news, in my effort to be particularly friendly, is that I can address two of your most salient questions by looking simply at page 1 of the brief submitted on behalf of the appellant. The question before this court, as framed by Mr. Kratovil, is, quote, whether the government may constitutionally criminalize a journalist's reporting on information he lawfully obtained from the government, which remains widely available and easily accessible on the internet about the residence of a high-ranking police official who lives more than 2 hours from the city in which he is employed. Now remember, they've insisted that this is an as-applied challenge. He's already published repeatedly that the high-ranking police official lives more than 2 hours from the city in which he is employed. So by the definition submitted by Mr. Kratovil, there's really not much left for this court to decide. Now, some of the things they said here suggested otherwise.
Your clients
But-
agree that there's no criminal liability for Mr. Kratovil for saying that the erector lives in Cape May?
Well, he's said it, and he has not been prosecuted. Obviously, the Police Chiefs Association is not responsible for prosecution, so it appears that there is no
What
criminal.
about civil liability?
Well, he, ironically, in this particular case, where there was a great discussion about prior restraint, simply got a letter said, you may be subject to civil liability. There was no prior restraint. You don't hear anything about prior restraint in the way they have framed the course of the case. They do cite the Pentagon Papers in the course of the brief, but there was no prior restraint. There was a letter that said simply what Your Honor just suggested, which is there could be civil penalties and there could be criminal penalties. That's simply a restatement of Daniel's law. And rather than take the risk of either of those things,
Well,
it was
it's
the
more than a
plaintiff who came.
restatement, that triggers the law. It doesn't apply unless there's been notice.
It is required by the law, and it provides formal notice of what the law says. And that's literally all it was. So there was no prior restraint. There was an effort to comply with Daniel's law, and that compliance put the plaintiff on notice of what Daniel's law said, which he may or may not have known already, and he's the one that came to court. So there was no prior restraint, and to Your Honor's questions about vagueness, in terms of what does home address mean, they don't raise the issue of vagueness. He has never once ever before any court in any brief said, I'm not sure what home address means. And I think as persons who are not necessarily learned in the law, you understand that if it's a small street, you say it's the first house on the right, it's red, you've identified the person's home address. If you say I live on Route 1 in Middlesex County, you have not identified the person's home address. But he's never said he was confused about it. This is an as-applied challenge, so whether or not that term is vague or not, respectfully, that's not before the court.
But before going to court, how did he know that he could publish that Director Caputo lived in Cape May?
Presumably, Your Honor, he read the words home address literally. So if I tell someone I live in a certain town, unless Teterboro, I think there's a couple of magical towns in New Jersey where there's 6 residents, but under almost any circumstance, if I tell you I live in a certain town, I've not revealed my home address. So my assumption, this is not the record, Your Honor, but in an effort to respond to your question, I believe he took those words literally and has never in any certification or brief suggested otherwise. And one of the other issues that has come up repeatedly is, well, when we talk about home address, even if we're talking about something very specific, isn't that widely available? I want to direct the court to something cited specifically by the trial court. It's a U.S. Supreme Court opinion. There's nothing like this in New Jersey, I say, yet, but it certainly is helpful. And it's language from the U.S. Department of Defense versus Federal Labor Relations case, 1994 U.S. Supreme Court decision found at 510 U.S. 487, and I'm citing at page 500. Quoting now. Any interest in controlling the dissemination of information regarding personal matters, and it specifically uses home addresses as an example, does not dissolve simply because that information may be available to the public in some form. So the U.S. Supreme Court has looked at this issue and has come up with remarkably clear language for what this court needs to wrestle with, and we respectfully request that that be included in a decision affirming the trial court. There was a lot of discussion about the Florida Star case, and it's my last point, if I may, Your Honor. So the Florida Star case, by its very language, was limited to the facts there. They had some real issues with the statute. They identified 3, and after identifying 3, in the third section, that is Roman numeral 3 of the decision, the U.S. Supreme Court said, our holding today is limited. We do not hold that truthful publication is automatically constitutionally protected, or that there is no zone of privacy within which the state may protect the individual from intrusion by the press. We, the Police Chiefs Association, certainly agree that the home address of prosecutors and judges and law enforcement officials designed to protect them, even after they retire, and their families, is at this critical moment in the state of our nation an issue of the highest order. The legislature found so, the trial court found so, we ask this court find so.
Does the statute define home address?
It does not.
And based on your arguments, I understand that you would interpret home address to be so-and-so lives at number 5 on Star Crescent Road in this town. Is that how you would define it?
It is, and I think you could also expose yourself to civil and criminal penalties if you do what I suggest. You get cute, you don't say 123 Main Street, but you say the house between 121 Main Street and 125 Main Street. You're identifying the home address. So certainly on that particular issue, some clarity from the court might be helpful, but I think that from the record below, despite the creative hypotheticals we discussed here, and discussed at the trial court too, there was no confusion alleged by a plaintiff as to what home address meant.
Meaning it was the street number and street name.
That's how it was taken by all parties at all times.
But even when we're all here today, he wouldn't know that by simply looking at the order that was issued by the trial court, would he?
Would the plaintiff?
Yeah.
Perhaps.
The order is a pure strikeout.
That's correct. So
Might have been better if there had been an order that said and defined what he could and couldn't do, correct?
So there's the order, and then there's the decision. And I was well trained to know the difference.
We only look at the order. At least
Understood.
that's what the appeal is taken from.
Understood. But the discussion below, and as I said, there is nothing in the record to suggest that there has been any confusion as to what that means. Given the workings of all the creative minds involved, as I said, I certainly, on behalf of the Chiefs Association, don't quarrel with the idea that there could be some clarity provided here. But with an as-applied challenge, there has been no confusion alleged. I wasn't sure what I could publish. And there's nothing in the record to the contrary. My final point, as we wrestle with these challenging issues, these are actually language, this is actually language from a Ninth Circuit opinion, but it's cited favorably by Justice White in his dissent in Florida Star. And so the case is Virgil versus Time Incorporated. And the citation is in the dissent. I'll give it to the court. 527 Fed 2nd, 1122. This is pinpoint site 1128. It's this. Fairly defined areas of privacy must have the protection of law if the quality of life is to continue to be reasonably acceptable. The public's right to know is then subject to reasonable limitations so far as concerns the private facts of its individual members. This member of the press was able to publish an article on a matter of public concern. The police director lives 2 hours away. He even identified the town. But if we are to maintain the quality of life as described eloquently by the Ninth Circuit, there have to be some limitations. And at this moment in time, limitations including the home address of these public officials is an issue of the highest order for our society, and we ask for a clear ruling of this court maintaining same.
All right, thank you very much.
Thank you very much, Your Honors.
Sorry. Morning, judges. Okay, please, the court, I'm Robert Cannon of the SKFA, State Troopers Fraternal Association of New Jersey. As with my friend, Mr. Gagliardi, I will not repeat, but I want to make some points. I will stay away from as applied versus facial, as I think it was the flavor of where we, at least the amici, believe our friend Mr. Shalom is moving with regards to his intentions on behalf of his client. With regards to the home address, one of the statutes does in fact use the home address. 56 NJSA colon 56 8-166.1 prohibits the disclosure or otherwise making available the home address or unpublished home telephone number of any covered person, as opposed to residential address. So there is one of the statutes that
But
says
it
the
doesn't
home
further
address.
define home address, what that means exactly.
It doesn't attempt to go further. It does even go on to unpublished home telephone number, but home address versus residential, they may have both been used. The SKFA has gone to great cost to attempt to enroll all of its members. The 1,930 currently serving state troopers in the state of New Jersey are, through a contract paid for by the union, all are intended to be, and we anticipate are now, enrolled in the Daniels Law portal.
This would prevent disclosure of their home address from the Board of Elections.
The intention of it is it absolutely should, as it is all websites controlled by state, county, and local government agencies. So it should have, and it would, if operating correctly. Now, the state Daniels Law was signed into law in December of 2020. The federal law followed 2 years and about a month later. The protections and the intention to protect certainly impacts our law enforcement, our state trooper members. The reason that partial address, at the trial level, the use of 123 Main Street as a fictional address is very significant for our members because of the nature of the vehicles that they might be caused to bring home. There are some things that on a small street, a lot of people might know. Perhaps a neighbor asked, hey, do you know where X person might live by their title or their public office, or whether they're a trooper or a cop? Hey, do you know where so-and-so is directed by giving a partial address.
Isn't that true also for a municipality in some cases?
Municipal officers or any, certainly with regards to if you give that municipality, and it might be small enough or few enough residents, absolutely. That is exactly the type of danger and the cause for this Daniels.
Is your client's position that release of the municipality is enough to subject the reporter to sanctions?
We think any portion of the home address should be determined and continue to be, as written in the statute, we think is too much. That's
So
right.
You disagree with some of the other colleagues that
For our members.
for your members, even the municipality or city where they live?
As a use of municipality, yes, and that's because there are 90 municipalities in the state of New Jersey where the local police department is the state trooper. This building is distinct. It is in Newark. If you live not far from this building, you might have only encountered, for much of your life, state troopers on the large toll roads. That's a completely different experience where the school resource officer, the guy working the football games and the basketball games is a state trooper. Very different experience beyond exactly where you are and the impact. So the living in that municipality, particularly in those that are distinct with regards to the few number of residential homes or the makeup of that municipality, could expose. Also, we talk about this is the intended news story. As data and technology and the internet go farther and farther and farther, what if that news story had pin drops of where some of these, the community of covered persons might appear on a map? Well, those pin drops might give a great inkling as to the closer location for the ability to find the community of individuals and our members.
Trying to clarify your particular membership's interest. If we were to do what plaintiff is asking, which is to only apply it as applied, it really wouldn't have arguably any precedential value or impact on your members, would it?
If you're inviting my further discussion of whether the plaintiff is looking for as applied versus a facial challenge, the as applied rule that would result from this Kratovil line of cases in your decision, if it were to say that he was permitted as a journalist in a news story to present more information than he already has, which there's not much more to present, it would be concerning to our members for the reasons that we talk about. You need only get in the neighborhood to find our members because of the vehicles. Maybe because neighbors know, hey, one of the people we know lives here, and it's ordinary that you might, is who the trooper is. It's just one of those known things, as other in the community of those protected. And it's of grave concern. You know, once upon a time, before the internet and the like, you'd have to go and find the cop that you want to target. 30 years ago, last June, in this building, on this floor, in the courtroom next, a horrible incident occurred. A detective leaving the stand in a judicial proceeding was gunned down and killed on this floor. A sheriff's officer protecting the courtroom across the hall came out and was shot. That, with the internet and where we are today, is what can be visited and has now been visited by one of the community of those protected by Daniel's Law in their home. It is here. Our papers talk about doxing, which is the publication to expose without permission someone's real name or address or job with the purpose to harass or harm. There's also swatting. Now, swatting, even very concerning, because what does it need in order to swat? A real home address, right? For the law enforcement response to a false call for assistance, it requires to be an address and someone to be sent somewhere. How is that information being disseminated? We are disappointed that our friends in journalism would wish to be the vehicle of giving that information out. Our legislature and the executive signing it, both at the state and the federal level, have said, that's it, don't do it. Now, the as-applied test has to do with this director, Caputo, who is a former law enforcement officer. Our concern for our members in giving any retreat from this minimal protection that we now have will have the impact of putting our members and the rest of the community of Daniel's Law's protectees at risk, continuing to be at risk. And by reminding journalists, by reminding members of the public, either directly by having them, our members in the Daniel Law portal, or by giving notice to them, there's at least an attempt and an opportunity to minimize the information that's out there. Prior to Daniel's Law, the trooper had no protection of their residential or home address. We don't want to see a departure from this little step that's been taken, and I appreciate all of you judges for listening to me this morning. Good morning.
Thank you.
Good because. Thank you, Your Honors. My organization represents the 21 prosecutors and assistant prosecutors in the city of New Jersey. Unless Your Honors have any questions for me, I will rely on my brief. Thank you.
Thank you.
Good morning, Your Honor. I believe it's still good morning, Your Honor.
Yes, it is.
Rich De Fortuna, Markowitz and Richmond, on behalf of the New Jersey State Lodge of the Fraternal Order of Police and its over 14,000 active and retired police officers and law enforcement officials throughout the state of New Jersey. These are frontline officers, frontline law enforcement officers, not only engaged directly with individuals suspected of crimes, sometimes violently and very oftentimes unpleasantly, but are later relied upon to testify against these individuals in subsequent court proceedings. Their lives are at risk every day while on the job, and that is a given. But New Jersey has recognized specifically that their lives and the lives of their family members who reside with them are increasingly at risk at their very homes. As individuals who have engaged with them while they are in their official capacity find it increasingly easy to locate their residences for the purposes of causing them harm, New Jersey is determined to try and limit the dissemination of any information that could assist them in doing so. And in doing so, in fact, the New Jersey legislature distinguishes itself from all of these other cases that have been before the United States Supreme Court and have been relied upon by plaintiffs in this case. In each and every one of those cases, and specifically the Florida Star case, the statute involved was there to protect the privacy of individuals, for the reputational harm to the individuals. They were not there to protect the personal health and safety of the individuals. So this is not one of the cases relied upon as a state utilizing its police powers to protect the health and safety of its residents, and they remain personal privacy cases only. Context matters, as Chief Justice Roberts held in Snyder v. Phelps. Here, the context is that plaintiff intends to issue Chief Caputo's personal home address in the context of a news article that will specifically identify him as a law enforcement officer on top of everything else. So context also matters, the basic First Amendment analysis, and again, Chief Justice Roberts. First Amendment is meant to protect the free and robust debate of public issues and to maintain a meaningful dialogue of ideas. In no way, shape, or form does the specific home address of Mr. Caputo, former Chief Caputo, further any of those goals. It is a specific private fact that has no bearing on the specific of the article which is intended to be published.
Counsel, what's your client's position with respect to identifying the municipality in which the director or former director lives?
Well, relying on the language of the statute, it doesn't say the municipality, it says the home address. And we maintain that the home address is to be protected. I would agree with counsel where if someone was to say in between 15 and 19 Rose Lane or the red house in the middle of the block would be problematic as well. Again, something that specific would go to mens rea as well, which I think would run afoul, in particular with the criminal statute involved. So, as far as trying to limit the state impact on the freedom of the press, I think this case provides you with an instance where they are trying to protect certain individuals, and it is a matter of the highest order for the state to do so, and it has done the least that it could do in order to protect further dissemination of the information, which could create great harm, and which the New Jersey legislature has found has been creating great harm to these individuals. The statute is very specific. It's not a general privacy statute. It is a health and safety and a protection statute. If you have any questions.
No, thank you very much. Appreciate it.
Thank you.
May it please the court, good morning. I just want to make a couple of points. I'm mindful of the court's concern about repetition. Why do we have to wait for there to be some specific harm before protecting our judges, our prosecutors, and our law enforcement officers? Like the STFA, the state PBA has gone to great lengths to get its members, its 33,000 active members, its 23,000 retired members, registered through the Daniels Law Portal. And given what's happening throughout the country, the increase in the incidents we've had for all persons covered under this act, we shouldn't have to wait for some type of particularized harm. This is not a general or in some fashion vague notion that there might be some harm. We're seeing this almost on a daily basis. And that's the purpose of Daniels Law, to make sure that as much as we can do through a statute is done to protect the judges, prosecutors, and law enforcement officers. There may be other ways, given the internet and all the other social media that's out there to get it addressed. But what the state can do to protect the covered individuals is what it's done in Daniel's Law. It is an interest of the highest public order, and there is no significant public interest in having, in this case, Mr. Caputo's exact home address published. The interest that the state is trying to protect is narrowly tailored, it's of the highest order, and we would urge the court, for those reasons, to affirm the decision below. Thank you very much, and I'm happy to answer any questions. Thank you.
That's everyone?
So it's your,
I'll be very brief. I'd just like to correct a couple factual things. The first, on the question of whether Cape May County Board of Elections referenced Daniel's Law and knew that Director Caputo was law enforcement, you can look to paragraphs 15 and 16 of our complaint. Daniel's Law was not mentioned. They did not, that wasn't why they initially didn't disclose. They thought that Brennan prevented them from
Giving a home address.
giving a home address initially, and then my client said that Burnett had overruled Brennan, which I concede is not actually what happened with Burnett, but it wasn't about Daniel's Law. It was about the availability of home addresses writ large for any member of the public. Mr. Gagliardi says that we've never raised the question of vagueness in any court. We actually discussed it extensively at the trial court, and I thought, wow, did I waive it at the appellate court? But footnote 4, which is on pages 31 and 32 of my brief, it's a full single-spaced page, talks about the vagueness of the briefs and the fact that the 6 parties on the other side didn't have a common understanding of what home address was, and how could a person of ordinary understanding have it if even they can't agree on it. You can.
But as applied in this case, your client understands that the current prohibition is on the street address and the number.
I think that's right. Although the order is merely a strikeout, my client did sit through the trial court's ruling, and he certainly is comfortable to say Cape May and is not comfortable to say more than Cape May. On the
and so
record,
on that point, getting back to it, what, and I fully appreciate the argument you're making about the editorial nature, but in evaluating when it's a public concern versus a private concern, how isn't that specific address a private concern?
because that's not the nature of the inquiry. The inquiry is, does it relate to an issue of public concern? Just like the name in BJF is not
The issue of public concern is this public official living far enough away from the city that somebody could question whether he's coming in on a regular basis or doing his job fully?
That is the nature of the issue of public concern. And then the question is, any facts that relate to that are matters of public concern under the jurisprudence. Just like in BJF, the issue of public concern was crime and police interdiction of crime. And the specific fact, the name of the rape victim, doesn't get treated differently because it's not necessary to the story. That's what Judge Ray did. He said, is it necessary or not? That's not the test. And
Counsel, what about the distinction that was raised by opposing counsel that, with respect to the intent to protect privacy in the statutes that were examined by the Supreme Court, and here that it's the intent to protect individuals from harm?
yeah, it's a compelling point. It's unfortunately just wrong when you read BJF. BJF was not just about privacy. If you see the debate between the dissenters and the majority in the Florida Star case at the Supreme Court, there's a lot of talk about the safety of rape victims. Again, the perpetrator was at large when the Florida Star published that case. Although there's some reference to the fact that it wasn't cited to below, at the Supreme Court, the Solicitor General for Florida, the person who's talking about what the statute is intended to, talks about public safety. This is not just a privacy statute, it is a public safety statute. And I'm going to get to that, just 2 more really quick cleanups on the record. I'm not sure whether it's fair. So I know that before this court, I cite to the news article where the reporter says I was able to Google it. But it was also discussed below. So in the third transcript volume on page 50, I discuss how it was easily Googleable. I mean, I had in front of me.
That's not really part of the record.
But there's a reason why.
That's a statement by a counsel about something that may have been there.
That's fair, Judge Gilson. It's unrebutted. But the other problem is, had I said I'm holding, which I did have, a PDF that has these results, I risk putting my, since I don't know what is proscribed by Daniel, so I don't want to say the address or enter into the public court record. So I probably could have moved it in under seal and perhaps should have. But I will point out that neither Judge Ray nor any of my able adversaries took issue with the fact that it was readily available. There was no correction asked for the New Jersey Monitor when they said they could find it. It may be harder to find now. I heard Ms. O'Connor say that they've taken efforts to clean it up, but the fact that it's taken months, that my client has been restrained for months, shouldn't inure to his detriment.
So in fact, let's assume that the address is readily available for purposes of this question. Does the state have an interest in preventing its further dissemination?
I can't say they have no interest, Judge D'Almeida, but that's not the question. I think it does diminish the need of the highest order once it's already out there. So it's a matter of degree, not kind.
You would certainly concede that even if something was available, if the New York Times published it, that's a very different scenario than if it's simply out there and you could do a Google search for it.
I can't disagree with that, Judge Gilson. I'm simply suggesting that the difference between 0 and 1 is bigger than the difference between 1 and 50 or 1 and 1,000. I just think that's the threshold where the government interest is at its apex when you're going from it's not available to it is available, which is why they could have put so much reliance on preventing the Board of Elections from disseminating it in the first place. I wanted to answer, Judge D'Almeida, the question that you raised about were we talking about the county or the city. Judge Ray's findings are at 3T61. He just says Cape May. Ms. O'Connor talks at 3T26, also says Cape May. I think we all inferred it to be the city, but none of us used precision in our language when we did. Last point, which is...
There's a further distinction. There's a difference between municipality and a mailing address as well. And some people's home address is a mailing address that doesn't match the name of their municipality. Princeton applies to 7 or 8 municipalities. But this is, so when I said municipality, maybe that isn't the correct thing. It's the name, the town name in the address is Cape May.
I take that point, and I think that just goes to that since we're just talking about in the as-applied challenge, what we're talking about is can he publish 123 Main Street, Cape May, which is not the actual address, to be clear. My friends talked about that we can't make First Amendment decisions based on an undifferentiated fear. And I just think, and of course we don't have to wait for specific harm, but it's useful to remind you what Justice Brennan said was needed to satisfy the presumption of to overcome the presumption of unconstitutionality of a prior restraint. The risk of harm must be inevitable, direct, and immediate. That's a big deal, and that is how you get to things like troop movement during a time of war. It's not general troop movement, it's troop movement during a time of war. You can assume that would be inevitable, direct, and immediate. But I don't think that a similar conclusion can be reached here. Unless the court has further questions, I'd ask you to reverse.
All right.
Thank you.
Very much.
Thank you.
We appreciate everyone's presentation. It was well thought out. We take the matter into consideration. Thank you all and have a good day.
Thank you, Your Honor.